Are you planning to travel by air to the U.S.? Before you leave Canada, you might find yourself interacting with an American customs officer. As of a few months ago, those officers working in Canadian airports were given expanded powers, like the power to interrogate you, detain you, even strip search you. The changes are part of Canada's new Pre-Clearance Act. Pantea Jafari is an Iranian-Canadian immigration lawyer. She joins us from Toronto. Hi, Ms. Jafari. Nice to see you. Thanks for making time for us.
Thank you for having me.
So I read the article by one of my colleagues this morning with great interest, and you vocalized your concern over this in that article. Tell me a bit about why this is ringing some alarms for you.
Sure. The main problem is that the present scheme of the Pre-Clearance Act doesn't have any control mechanisms in it for travelers to hold U.S. officers accountable. So there's no recourse to Canadian courts because of the immunities built right into the system. Both the country of the U.S. and its officers will have pretty much blanket immunity, except for like a complaint mechanism, which is really non-starter to begin with. And then so as a result of that, without any mechanisms to hold them accountable, the vast powers given to them that allow them to use the discretion to their level of deemed appropriateness leaves a lot of discretionary power that can be abused, which causes concern.
Can you give me a bit of an example? So for our viewers watching who don't intricately know the law, how would it have worked before this law came into force? Like one specific example of what a U.S. officer could do versus what kind of powers they might have now?
So one of the most concerning changes is that previously you were allowed to leave a pre-clearance area no matter what, unequivocally. If you felt the line of questioning was problematic, was for whatever reason, inappropriate, uncomfortable, whatnot, you had an unequivocal right to withdraw and say, I no longer want to enter the U.S. And as a result, the authority and ability to continue to question you would cease and you would immediately be allowed to leave the pre-clearance area. But presently, that right has been circumcised to a point, and the officer now has a right to determine your reason for withdrawal, and as a result of that, they have the right to continue to question you. You are subject to the right to the obligation and responsibility to continue to tell the truth, to follow the officer's directions, and if you are resistant for whatever reason, that could be deemed cause for suspicion and escalation from there up to detention, strip search, and what else. So it's a pretty big concern.
So as a result, does it make you hesitant to travel there?
Absolutely. I am both an Iranian citizen as well as an immigration lawyer with a vast Iranian and Middle Eastern client base. So without there being any limits placed on the determination of the reason for withdrawal and the questioning that can occur there, especially when you're obligated to answer the questions posed to you and to follow the instructions of an officer, that causes me great concern, because not only can I be questioned about my own personal history or ties to Iran or whatnot, but that of my clients as well. And there are no specific mechanisms built in for solicitor-client privilege, which is something we really fought for at the consultations both at the House of Commons and at the Senate, and that hasn't been built in. So, if I'm instructed to hand over my cell phone, my laptop, all of which contains such data, even if it's cloud-based, that becomes a great cause for concern.
You mentioned a little earlier about, or talked a little bit about the lack of recourse. And I want to read to you something that the Prime Minister said about this bill. It's a statement from 2017, but I just want to get your response to it, because he defended it by saying, when you're doing pre-clearance in Canada, the Canadian Charter of Rights and Freedoms and Canadian laws are in place. So there is extra protection when Canadians go through American customs in Canada, because they are protected by the Charter on Canadian soil. So he's effectively arguing here that the Charter will be that mode of recourse. What's your reaction?
Yeah, initially I was kind of shocked by that kind of rhetoric, but it's something that's starting to set in as being pretty standard in politics. But the Prime Minister, I'm sure, is well aware that that is a complete misnomer and a complete falsehood, because even the Privacy Commissioner testified openly that this is unequivocally not the case. Because while we have the theoretic protection of the Charter of Rights and Freedoms, in practice, because we don't have recourse to Canadian courts to drag an officer to Canadian jurisdiction to be held accountable to their conduct, that that protection really does not exist whatsoever. And I'm sure the Prime Minister and the Minister and the government is aware of that. So I'm troubled by the fact that they continue to put that misinformation out into the public.
All right, I've got to leave it there. But thank you very much for your
Thank you.
time this evening. I really appreciate it. That's Pantea Jafari in Toronto. Thanks, Ms. Jafari.
Thank you.
Hi, I'm Vashi Capellos, host of Power in Politics. See more of our show by subscribing to the CBC News channel or click the link for another video.